Okay, so that's the deputy from the sheriff's office describing the scene. We saw some pictures. Obviously, we don't want to show you the very gruesome pictures of the child, but he's talking about the bugs that he saw that came from the area. And one thing that he mentioned that's been brought up twice, Ron, is the fact that there was a candle, like an air freshener, right near where the baby is. What does that say to you as a former prosecutor? By the way, this is Ron Blitzer. I didn't introduce him. He's a former prosecutor, senior editor here on Law&Crime.com. What does that say to you about potential intent?
It says to me that the defendant here and the defendant in the previous trial knew what was going on, that they were certainly aware that there was a smell coming from this room, and they put a candle there, in my opinion, in order to mask that, just so that they could continue to go about their lives.
Yeah, they had the candle in the kitchen and the air freshener. And then the prosecutor was also having the deputy point out about the fresh diapers, about the new infant diapers that were also in the house. Why do you think that's important to this case?
Because it shows that, the baby was found having not been changed for so long, but when you see fresh diapers in the house, it shows that it wasn't for a lack of ability. It shows that this was intentional, that no effort was being made on purpose, in my opinion. To take care of this child. They had the resources, they had the ointment they talked about, they had the fresh infant diapers sitting in the house, yet these parents allowed this child, 4 months old, little Sterling, to sit in the swing for days on end without getting a diaper change, according to investigators. It's such a sad story. We have to take a quick break here on the Law and Crime Network. We'll be back in just a few minutes to bring you back inside this case in Iowa. Stay with us. All right, just listening to some testimony from the deputy talking about what he found inside the house, particularly about the baby bottles and the fact that there were no fresh ones in the sink that had just been washed. The only two he found were one in the room and one was in the corner in the kitchen there, and they looked perfectly dry. They looked like they hadn't been used. And of course, anyone, Ron, that's had a child knows, especially a child that age, when you're not breastfeeding, that you're constantly feeding the child, and there's going to be dirty or recently cleaned bottles, multiple ones in the sink. Yeah, that's significant evidence that they still intentionally were not taking care of this child. Like you said, if they had been regularly feeding this child, there would have been evidence of either freshly used or freshly cleaned bottles. And we didn't see that here. And this just adds to the list of evidence here showing that this was no accident.
Right. And again, the crux of the defense here is going to be this diminished capacity and the fact that, according to the defense, she was suffering from postpartum depression and that she was on meds, well, really drugs, when this happened. The fact that they're showing a bottle that has obviously not been used for a very long time means that this was not just an isolated incident of neglect or abuse, that this had been going on for quite some time, besides the fact that he had been in the swing for at least 14 days, according to investigators.
Right. This isn't a case where this was one day something bad happened because a parent wasn't paying attention because they were incapacitated. This is a case of, for days, for weeks, nothing had been done to take care of this child.
Okay, Ron, I have to cut you off there. Unfortunately, we have to take a quick break. I'm going to sign off. Linda will be signing back on. Stay with us here on Law and Crime.
Well, this is the detective, or one of the investigating officers who was called to the scene and then came back to the scene to do some measurements, and he found some things in the child's room, Sterling, who was 4 months old when he's dead now. Ron Blitzer, who is our senior legal editor here at Law and Crime, we've been on together, right? So you know I'm going to give you the hard question. Right now, as you sit on that jury, is there anything the defense could do to prove to you that she was either intoxicated or that she had the postpartum depression so that she couldn't monitor or give some instructions to take care of that child?
In a word,
no.
Oh, that was quick. We got to go a little longer than that. Okay, so let me be the defense attorney then. If a doctor comes in and says, look, the people screwed up. She left the hospital. She had symptoms in the hospital record. She had in the umbilical cord there was methamphetamine. She was clearly meth addict. They put her that she couldn't breastfeed. That's why she's bottle feeding. And then they sent her home without any monitoring. Would that help change your mind? In a word,
it might help in terms of maybe, if there's a lesser charge possibility, or depending on sentencing, that could help her there. But still, as I was saying to Rachel earlier today,
Rachel Stockman, our president of Law&Crime.
This isn't a case of one accident that happened on one day where you have a defendant who was incapacitated and wasn't in her right mind, and something got past her, and the child ran away or something happened. This was a sustained period of neglect, as we can see from evidence showing that for days and weeks that nothing was done to take care of this child. So, if this was just something where maybe the child wasn't fed for several hours and suffered as a result of that, then maybe I could see, okay, she wasn't in control.
But let me just interject. If the husband is home, and they're not man and wife, but they're basically our man and wife relationship. Cheyanne, if Zachary's home and every night he goes in and look at the child, because you're going to be a new father, right? You're going to be looking at that child all the time, and sees that the child's getting thinner and thinner, and then can't even cry because it's so dehydrated. Do you place more blame on him if you're the jury? Or do you then say, oh, wait a second, okay, no, I don't place more blame on him?
I don't place more blame on him. I place equal blame here. And the father has already been convicted of murder in this case. And, we saw from having fresh diapers in the home that weren't used, to bottles in the home that hadn't been recently cleaned or, used according to, the state that they were in, to candle and air freshener that were used, apparently, in my opinion, to mask the smell that was coming from the room. I think there's too much there to show that the people there, the parents, both of them, knew what was going on.
Well, but let's go back. You know what? Guess what? I have so much to talk to you about with this case in terms of that, because it's a serious case. We have a death here and already a conviction. But guess what we have to do? We have to go to that little break. So we'll talk on the way back. Well, that was Jeremy McGrath. He's a paramedic. He arrived at the house on August 30th, 2017, basically to see this horrible death, a child who he said had rigor mortis, that therefore had clearly been dead for a period of time. In this, just awful. I mean, he was a very good witness, wasn't he, Ron?
Oh, absolutely.
And let me just ask you, why?
Because that last piece that we heard really blows a hole, in my opinion, into a defense argument. We were discussing earlier, as to whether or not, she, was
postpartum depression.
Exactly, and didn't know what was going on, was incapacitated. But this shows that she claimed that she last saw the child alive the night before. Evidence strongly indicates that that is not true. The evidence.
Well, he did say rigor mortis was 12 to 24 hours, and it does start, I can tell you from experience, because I happen to be married to a medical examiner, about 2 hours after someone dies in the jaw muscles. So it could be consistent that the baby was alive, around that time.
All right.
Consistent.
Okay.
That was easy. I wish all prosecutors were like this. Go ahead. I interrupted you.
Yeah. But she doesn't offer any explanation here. She claims that she last saw the child alive the night before.
Right.
It didn't give any indication that there had been anything wrong. Yet we've seen all this evidence about how the child hadn't been changed for a long time.
9 to 14 days.
That there were
dehydration.
Bugs, that there were maggots, bugs growing out as a result. It's disgusting, but that's what happened. That there were fresh diapers in the house, so it's not that she was unable to change the child. There were no freshly used bottles, so it doesn't look like she had been feeding the child anytime soon. So if you have all of that, plus her saying that oh, she saw the child the night before and it was fine.
Yeah.
Well, something doesn't add
She
up.
said the child was alive. She didn't say the child was fine. But, you know, I'm sure we're going to hear about all this when the defense starts actually summing up, because that's what they're probably going to do. They're probably, unless they have expert witnesses. But right now, because we want to get back to the court soon, we have to take a break. Okay, so what they're about to show to the jury is actually the room where the 4-month-old child, Sterling Cohen, was found dead. That was the bed that has been testified to that is found on one of the walls. And we're not going to show that to you. We don't need to see that. We don't need to traumatize our viewers. The jury is going to be traumatized enough. But we do need to talk about it because it is an important issue. Ron Blitzer, who is the senior legal editor here at Law&Crime. Ron, before the sheriff got on the stand, there was a previous witness. His name was Jeremy McGrath. He was a paramedic, right? And he said, he was asked the question, from the prosecution, did you see any impairment? And I'm sitting here waiting for an objection, an impairment of Cheyanne Harris, because he spoke to her. All right, I'm waiting for the objection, no objection. And he says, in my opinion, and I'll quote it directly, no, she was not impaired in any way. I thought that was a little strange because he's not trained to recognize impairment of postpartum depression, I don't think. What did you think about that?
I was very surprised that the defense did not object to that. I certainly would have if I was in their position. It calls for speculation. It calls for conclusion based on training that we don't know whether or not he's had. Those are questions that need to be asked. That's an issue that needs to be raised. And the witness being able to just tell the jury, no, she seemed fine to me, no impairment there, that is huge, because if the prosecution is showing this was an intentional murder and the defense wants to argue, no, she was impaired, it was intoxication.
And it could be drug intoxication. I want to make it clear to our viewers, it could be drug intoxication. We're not talking about liquor intoxication.
Right. So if the defense is going with an intoxication defense and you have a witness saying, no, she seemed fine to me, at least when it comes to intoxication or impairment, and there's no objection to that, that gives a jury the impression that, oh, she wasn't really intoxicated.
And remember, there's a previous witness who said there was no affect by the parents. So how do you reconcile the fact that there may be no affect, which really shows that she could have some kind of mental impairment, with the fact that she seemed fine within the period of half hour?
Yeah, if I'm the defense, not only am I objecting to the question, but I'm certainly going to cross-examine and say, well, have you been trained to this? Do you know that one could be impaired or intoxicated and you may not necessarily see signs on the surface?
Right.
And you got to drill those points home if you're the defense. And the fact that they failed to do that is really questionable.
And here, when we talk about this is nothing to be taken lightly, because this woman, when she had the baby, did show that her umbilical cord had meth. But, the sheriff is still on the stand. The pictures, the body cam is over, so we're going back into court, and let's listen to him. Well, that was the end of the testimony of the sheriff of the county, Chickasaw County, where Sterling Cohen died. He just said that the mother, Cheyanne Harris, was crying and upset in the kitchen. But you know what we have to talk about right now? My favorite show. It is Aaron Keller, who has the Daily Debrief, and I'm really excited about the Daily Debrief tonight. Aaron, why?
Because you're going to be there,
yes.
Linda. I'm glad it's your favorite show now. I've hit a new benchmark in my career milestones with that glowing praise. We're going to break down the 2 trials we're covering here on the Law and Crime Network. Of course, the Cheyanne Harris case. We're going to dial back to opening statements in this case and really try to deconstruct this defense theory, this defense excuse, some people would say, that this was a mix of depression and drugs that led to the baby's death. Is the mother responsible legally? That's one of the questions we're going to talk about. Plus, we're also paying close attention to the McStay family murder case out of Southern California. Testimony is on hold in that case. It's giving us a bit of a pause to catch our breath and go back over some of the key evidence that came up over the last couple of days. It has to do with blood and money. That's the bottom line in that case, the 2 big pieces of evidence that came in this week. Those stories and more on the debrief coming up at 5 o'clock Eastern.
Wow, stay tuned, 5 o'clock Eastern, the Daily Debrief with Aaron Keller, and I will be his guest. I can't wait. But right now, so that we can get you back in the courtroom soon, we have to take a break. A little break. Stay with us. Well, that is Chief Deputy Reed Pallow. He's telling us when he responded to the scene of Zachary Cohen's death on August 30th, 2017, he was astounded by how small the child was, and he did try to talk to the mother. Now, Ron Blitzer, our chief legal editor here at Law and Crime, okay, you and I were talking while this is going on about this defense, which is going to be postpartum depression versus postpartum psychosis. Now, there's a difference in how many women get this after each one of these, isn't there?
Yeah, psychosis is much more rare. Postpartum depression, you see maybe roughly 15% of the time within the first year after childbirth.
Now, interestingly enough, England classifies the death of a child as infanticide within the first year, which is a lesser crime than murder. We don't have that distinction here. Do you think that, given what you've heard so far, that she could have had, that Cheyanne Harris could have had this depression along with this meth addiction that caused her to leave the child alone?
It's hard to say. It's certainly possible, and it's something that the defense may be wanting to bring up as a possibility. I don't know for sure, but anything that the defense could use to try and show the jury that the tragedy that happened here was not a malicious killing would work to Cheyanne's defense.
And the problem that may happen, though, is that you do have Nala, the 2-year-old, you have the dog that's well-fed, the husband's well-fed, the mother's well-fed. Somehow, something went wrong, purposefully, neglectfully, or because she had some kind of diminished capacity. And that's what this trial is all about. Stay tuned. We have to go to a quick break. Ron Blitzer is leaving us. I'm going to cry, but we will be back. Thank you.